Thank you.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon. We're happy to have you with us. Not seen by you, but with us here, and she can see you and we can see you, and you can see us, but not our third colleague, Judge Rushing. So we're going to try to be mindful of the fact that she'll be wanting to ask questions and defer to her because we can't see when she's getting ready to do that. We're happy to hear argument in our first case, number 20-1191, Wikimedia versus National Association of Criminal Defense Attorneys. Mr. Toomey, we're happy to hear from you.
Good afternoon, Your Honors. May it please the court. I'm Patrick Toomey, representing Appellant Wikimedia Foundation. This appeal is about Congress's decision to authorize review of intrusive surveillance activities in the courts. We explain in our briefs why Wikimedia has put forward more than enough evidence to defeat summary judgment, evidence on which a reasonable fact finder could rely to conclude it's more likely than not that some of Wikimedia's trillions of communications have been subject to upstream surveillance. These specific facts support Wikimedia's standing and defeat summary judgment. The question is what happens next. The government argues that the case still must be dismissed based on state secrets, but Wikimedia has put forward more than enough to trigger FISA's protections, so it's FISA's procedures that control here. That's the real heart of this appeal, Your Honors. The question of whether a plaintiff who comes into court with extensive public evidence of surveillance can obtain judicial review as Congress mandated in FISA. I'd like to begin there and then explain how this case should go forward using the in-camera review procedures that Congress enacted. In FISA, Congress authorized civil suits challenging unlawful surveillance and specified procedures for litigating those claims. Nonetheless, the government argues that it has the power to block this court review of FISA surveillance by asserting the state secrets privilege.
Well, isn't essential to the government's argument its claim that 1806F only gives the government as it puts it, a shield? It doesn't give you a sword.
You're right, Your Honor, that the government argues that 1806F only applies in criminal suppression proceedings or similar proceedings. But other courts have repeatedly held that these procedures are available in civil cases like this one. That's what the Ninth Circuit held in Fazaga. The DC Circuit recognized it in the Barr case, and other district courts have found the same, including in the In Re NSA Telecoms case.
To be sure, but if you just look at the structure of 1806 itself, it looks like all of the other subsections are government protection, if you will.
I don't think
can we agree on that?
No, I'm afraid I don't agree with that, Your Honor. First of all, the text of 1806F itself controls, and that the text of the third prong, which governs whenever an aggrieved person files a motion to discover or obtain FISA-related information, is broad and clear. And because that text is not ambiguous, it controls here, and it covers circumstances where a plaintiff like Wikimedia has sought to discover FISA-related information in a civil case.
Mr. Toomey, can you back up? You started with the text, but what about the title of the statute, which suggests, consistent with the government's view of things, that it only applies when there's some affirmative use of this information being used by the government and or some attempt by a defendant to rebuff that use via a motion to suppress or something like that? That at least seems to make sense based on the heading of the statute. Why isn't that persuasive, or at least some indication of what Congress intended?
Well, the heading of the section is use of information. It does not specify use of information by the government. And of course, the title doesn't control the meaning of, in the extent that it's inconsistent with the words of the statute itself. Congress.
I'm sorry, isn't there federal law that the titles don't make any difference? There's certainly a state law.
That's exactly what I'm saying. The title does not control the meaning of the text. And to the extent the government's arguing that that determines the meaning of the statute, we disagree. But again, going to the text of 1806F itself, Congress was clear when it enacted FISA that that provision controlled in both criminal and civil cases. And the statute does not contain any of the limitations that the government tries to read into that third scenario under 1806F. If notice of surveillance was a precondition to parties using 1806F, Congress could have stopped after the first prong in 1806F, the prong that says when a person has received notice. But Congress, yes, go ahead, Judge Rushing.
This is the invisible Judge Rushing. Thank you. But one of the limits that's explicitly in the text is that the person must be an aggrieved person, which Congress has defined as someone who is the target of an electronic surveillance or any other person whose communications or activities were subject to electronic surveillance. Why doesn't that limit the provisions, even if it doesn't create this, solely government shield version of the statute? It at least limits it to individuals who, in fact, were surveilled and are attempting to litigate regarding that surveillance.
So you're right, Judge Rushing, that 1801K defines who is aggrieved, but it does not say what a party must show in order to be aggrieved and to utilize Section 1806F. And in the ordinary course of civil proceedings, a party is entitled to discovery after it overcomes a motion to dismiss and has put forward specific plausible allegations. And that is the natural reading of the statute here in civil cases where a plaintiff is challenging FISA surveillance.
Hold on, Mr. Toomey. I think we may have lost Judge Motz.
No, it's just my video went off. I can still hear you. So maybe
okay.
Yeah. So go ahead. I'm going to try to get it back.
Okay, thank you. So as I was saying, the statute, neither 1801K defines what a plaintiff must show in order to be aggrieved. And what Congress was attempting to do in 1801K was to make clear that an aggrieved person is someone who falls within the scope of the Fourth Amendment protection, a person who was targeted using FISA surveillance or who was otherwise subject to FISA surveillance. Now, I also want to say that the government's reading would require courts to essentially conduct a bifurcated mini trial on a person's aggrieved person's status in every civil case involving FISA surveillance. Because of what the implication of the government's argument is that a person should have to prove they are aggrieved before they're entitled to discovery. As Professor Vladeck lays out in his amicus brief submitted in the state of the Zaga court, explains in its decision, that's inconsistent with how discovery typically occurs in a civil case.
Or it could just be an indication that as the government suggests, that the in-camera review proceedings have to do with determining the legality of surveillance that people know actually occurred, rather than with determining whether affirming or denying whether it occurred.
Well, the standing and the lawfulness inquiries are inherently intertwined in Fourth Amendment cases. The question of whether a person was surveilled and the question of how a person was surveilled are intertwined and often rely on review of the exact same materials or overlapping materials. In these types of cases, it would be the FISA application and the intercept. And the other thing that I want to emphasize for the court is that the government's interpretation is at odds with the statute structure and the comprehensive scheme that Congress enacted, because it would mean that the government could control who could avail themselves of the civil remedies that Congress created in Section 1810 at the same time that it enacted Section 1806F. And because it would mean that a person would have to litigate the question of whether they were surveilled to prove. And in the course of that threshold proceeding, the government could assert the state secrets privilege exactly the way that it's asserted here. And that would make American citizens' ability to avail themselves of the remedy that Congress created completely contingent on whether the government had admitted the surveillance. And Congress—
But isn't that, Mr. Toomey, I mean, that's always the case when the government asserts the state secrets privilege. There may be a remedy that a plaintiff may be entitled to, either in a civil or criminal case, but that remedy is foregone because of the higher interest of protecting the government secrets.
That is true under the common law state secrets privilege, Your Honor, but in FISA, Congress is clearly setting out to do something different. The structure of the statute and the legislative history makes it clear that Congress is seeking to balance civil liberties against national security and to create a set of procedures that allowed plaintiffs with substantial claims of illegal surveillance to obtain a ruling on the merits and where appropriate, to obtain a remedy. And Congress—
So with respect to that ruling on the merits, so you've made the point, I guess, that the caption or heading of the statute doesn't control. Let me see if the subheading might be more persuasive. So 1806G talks about the remedy that's allowed in these cases, and it begins with the caption that says suppression of evidence, denial of the motion. And the government argues that this just doesn't make any sense, the argument you're making, because ultimately what the remedy is a grant or denial of a motion to suppress. So what's your response? I mean, that's not an adjudication of the merits, but simply a ruling consistent with the balance of the statute that really deals with the use, improper or otherwise, of information in a particular context.
Well, 1806G, again, based on its text, is not limited to suppression. The text of 1806G says that a court can order suppression or other appropriate relief based on the aggrieved person's motion. And that clearly encompasses relief other than suppression as the text goes. So again, we don't think that 1806G forecloses plaintiffs from using 1806F in the way that the Ninth Circuit has recognized in Fazaga and in the way that the DC Circuit acknowledged was available in the Barr case. Now, I want to pull back for a moment here, Your Honor, and touch on one of the big picture themes of this case, which is Wikimedia has put forward compelling evidence of surveillance. It has trillions of internet communications, web communications. The government has acknowledged that it conducts the surveillance on international internet links, and Wikimedia's communications traverse all of those things. The government has acknowledged that it collects web activity, precisely the type of communications that Wikimedia engages in. And Wikimedia has put forward the expert declaration of Scott Bradner, and Scott Bradner's conclusions have been endorsed by nearly 24 technologists in the amicus brief submitted in this case. The government's theory, in order for the government to be right that Wikimedia lacks standing and is not aggrieved, the government would have to be filtering out every single one of Wikimedia's communications with surveillance. And the government has not put forward a single piece of evidence that supports the existence of a Wikimedia.
Well, they have an expert who says that they could filter out.
That's right. They have an expert who says, in his view, it would be technically feasible. But the point I want to emphasize is that the government's argument is not really that if Wikimedia had more evidence, had more experts, it could satisfy the requirements of FISA and use those procedures. But the government's argument at the end of the day is that it has the power to decide who can proceed to obtain court review under FISA and who cannot. And our claim is that that is inconsistent with the text of the statute, structure of the statute, including the remedy that Congress created in Section 18. the legislative history which acknowledges that the government may have to proceed in some cases in civil suits brought against it, and with Congress's overarching purpose in FISA, which was to rein overreaching executive branch surveillance.
Can we go back to Judge Rushing's question about the aggrieved person? And as I read your brief, you acknowledge that the standing and merits issues would have to be determined together. You say there's no problem. The government says they're always bifurcated, that's the uniform practice.
That's right. The government makes that claim, Your Honor, but as we point out in our brief, it's not true in the first place. There have been FISA cases where standing and the merits have been litigated at the same time, including the district court proceedings in the Clapper case itself. And second, there's nothing in the statute that requires courts to bifurcate. In fact,
no, to be sure. Well, let me put it to you this way. In the Supreme Court, often the question is, well, how does this opinion write? And so what would we, if we came out your way, what would we be saying to the district court? Don't bifurcate? What?
That's a good question, Your Honor. I think the court could, we think the district court proceedings should go forward on both standing and the merits together. And we think that the court should suggest that the district court proceed in that way because it preserves the greatest flexibility for the district court in deciding how to rule down the line. If the court is ruling on standing and the merits, it has the option, if it wishes, in the way we describe in our brief, to issue a short ruling that does not determine whether it has ruled on standing or the merits. I see my time's up.
You can go on, and my colleagues may have additional questions too. So finish the answer to that question.
Sure. Thank you, Your Honor. And so we do think that the case should move forward on both, and that preserves the greatest flexibility for the district court to take steps to ensure that it does not unnecessarily disclose any sensitive information. But one important point on that, Your Honor, is that the government makes obviously many arguments about what it claims is the potential for sensitive information to be disclosed. I want to emphasize that issue is not relevant to the legal question before the court, which is whether FISA controls here. Congress made a judgment when it enacted FISA, and that judgment is binding. It balanced the risks of disclosure in the types of in-camera proceedings that it prescribed against what it saw were the benefits of ensuring that parties could obtain judicial review of far-reaching government surveillance activity. And go ahead, Judge Motz.
No, I was going to let my colleagues ask questions if they had them. I thought you'd answered the question. Judge Rushing, do you have any further questions?
Yes. If that's all right, I'd like to.
Oh, yes. I'll give it going at the same amount of time.
Thank you. I had a couple of questions on your establishing standing on these prong 2 and prong 3 of what we're calling the Wikimedia allegation. The district court on prong 2 relied on this statement by Director Coates about that on circuits carrying international internet communications. You mentioned that in your brief, but don't really rely on it. And I just wondered if you have a response to the defendant's argument that a circuit carrying international internet communications could be found domestically, that term does not have to refer to international circuits found internationally, but could in fact be domestic because those circuits also carry international internet communications.
Yes, Your Honor, a circuit carrying international communications could be domestic. But what we point to is the government's own disclosure in the Fisk opinion showing that it conducts this surveillance at international internet links. And you don't have to concede anything you don't want to, but I just want to make sure I understand. Are you agreeing with the government that
the district court erred in relying on that statement by Director Coates for this to find prong 2 satisfied?
We certainly don't agree the district court erred. We think that there is stronger evidence that supports Wikimedia's position, and that, Your Honor, is the evidence we cite, the evidence about the surveillance happening at international internet links, because that is a more specific term, and that is the disclosure that Scott Bradner focuses on, in addition to others, in describing why Wikimedia's communications are subject to upstream surveillance as they traverse those international internet.
And that's where you have a disagreement about whether that term is the same as the term circuits, and the district court concluded that that was a state secret, and you're not contesting that ruling, that whether these two terms are equal is a state secret. You're just saying your expert can, without knowing the secret, your expert can determine from public evidence that in fact those terms are the same.
We are contesting that it's a state secret, Your Honor, and because the information is public. So and this may be—
Where in your brief do you contest the district court's conclusion about the 7 categories of state secrets? I saw a footnote kind of alluding to maybe that you have qualms with one part of one of those categories, but I don't recall you contesting the conclusion that these 7 categories were state secrets.
Your Honor, we say at multiple points in our brief, and we say this in the text of the brief, that to the extent that the information is already publicly available in the government's own disclosures, it is not protected by the state secrets privilege, and that the categories that the district court described were therefore too broad to the extent that they covered information that the government itself had already made public. So where the government's own disclosures, as in this instance, show that the surveillance occurs at international internet links, the district court is entitled to rely on expert testimony about what the meaning of international internet link is to a person a networking expert who is familiar with the meaning of those terms in the context of the internet backbone.
Yeah, I don't want to keep us going on for too long, but I do have one more question, if that's okay. On the prong 3, there's an amicus brief by the technologist that raises the idea that tier 1, what's the term here? That folks who are the tier 1 ISPs and encapsulate or wrap the headers so that what the government's claiming it does in terms of filtering based on header information would be impossible on those with those ISPs. I think that's an interesting, I'm interested to hear what the government has to say in response to that, but I wanted to ask you whether any evidence about that was brought up in the district court. I didn't find anything in the JA, but it's a big record, and I wanted your help on looking to see whether this header wrapping or encapsulating was brought to the district court's attention, or whether there's facts in the record about it.
I don't know the answer to that off the top of my head, Your Honor. You're quite right that there's an extensive expert record here. I, of course, am happy to try to find the answer to that for you. I will say that we have put forward in the record extensive evidence that the government is not engaging in filtering in the way that the government's expert hypothesizes. And if the government is not engaging in filtering, then it is necessarily copying and reviewing some of Wikimedia's communications. And Wikimedia's evidence, of course, on the standards that control at summary judgment in this case and every other case is entitled to be credited as true. Reasonable inferences are to be taken in Wikimedia's favor, and the district court failed to apply those standards properly in this case.
Judge Diaz, do you have any additional questions?
I don't, thank you.
Thank you very much. almost 8 minutes. And so I will give the government 8 minutes and let you reserve some time for rebuttal too.
Thank you, Your Honor. Good afternoon, and may it please the court, Joe Busa on behalf of the government. The district court correctly denied plaintiff's motion to compel discovery into highly classified facts regarding the location, subjects, and methods of NSA's upstream surveillance. Those matters are state secrets whose disclosure would cause, quote, exceptionally grave damage to national security. And we urge the court to review the classified declaration to that effect. Now, those privileged matters are absolutely privileged under this court's case law applying the state secrets privilege. They can't be used by the government or by plaintiff or by a district court sitting in camera. The district court also correctly granted summary judgment to the government because that privileged information will be so central to the case that any attempts to proceed will threaten that information's disclosure. That includes in-camera use of that information. It was antithetical to the core principles of the privilege. And there's a lot to address in this case, but I think it's most important to start where the court spent most of its time with my colleague on the other side. And that's the contention that an obscure provision of the FISA applies here and displaces the privilege, but it does no such thing. And I think it's important to start just by looking at 1806 as a whole, to read the statute as a whole in order to understand what it's doing. And I would start with the title of the statute. The Yates case actually makes clear that the title of the statute is relevant to the interpretation of the substantive provisions within the statute. And the title is use of information. Now, whose use is it? It's the government's use, as illustrated by all of the subsequent provisions of that statute. A says that the government's use of that information is subject to minimization procedures. B says that the government's use of that information can only be done with the Attorney General's permission. C says that the government's use of that information in litigation requires the government to provide notice. D says the same thing about a state government's use of that information. E says that when we're using information against somebody in litigation, that person can seek to suppress that use based on allegations of unlawfulness. Now, taking that as background, it's clear what the procedures in F are for, therefore resolving those specific issues, the government's ability to use the information or not by application of in-camera procedures if we invoke them. That's why the statute says if the Attorney General invokes them. It doesn't say the Attorney General shall invoke them whenever some plaintiff wants to make us. And the key issue here, as the court was focusing on during its time with my colleague, is that the decision inside an F procedure regards the legality of surveillance to use that as the rule of decision about granting or denying the motion that brought entry into the F procedures. It has nothing to do with final...
Just TSA, I'm sorry to interrupt.
Of course.
So with respect to 1806F, I'm interested in, I think obviously interested in that third subset of that section, and which you've sort of touched on here generally, but in your brief at page 18, you said, and I'll just quote it here, that circumstance, little I3, is not a free-floating right to discovery. And then you say that's rather, it's a description of a situation in which certain motions made pursuant to some other provision of law may be removed by the government from adversarial adjudication in open court and submitted for in-camera determination. But then you stop and move on to something else, and you don't give us any examples of what it is that you're talking about. So I'm trying to figure out exactly what that means. And can you give us an example of what you mean?
Yes, Your Honor. An example would be a discovery motion seeking to discover information in order to challenge the government's ability to use it, to figure out if the information the government is using is the result of electronic surveillance, or to figure out the scope of what ought to be suppressed based on a taint theory flowing from unlawful surveillance, right? So it's a discovery motion that is attendant to the government's use of that information. That's consistent with what all of 1806 is all about, what the prior two prongs of 1806F are about, and it's what the statutory text other means in this third prong. It's not talking about any motion to obtain or discover information. It's talking about any other motion to obtain or discover, in contradistinction to, linking to the prior two circumstances, the chief one being that motion to suppress under E, which is what's referred to in the second clause. This is just like what the Supreme Court confronted in the Vigay decision, where it confronted language that referred to a crime of arson, burglary, murder, or any other crime with a substantial likelihood of personal injury to a person, I believe is the language. And the Supreme Court said you don't just look in isolation at whether a crime might have a substantial risk of injury. The word other there is telling you, you link it back to the prior elements in the list and you figure out whether it's similar to those other prior elements. That's also what's going on here. So we think that's clear from the context of the statute, the fact that the resolution of the motion depends on the legality of surveillance, which is true when you're talking about surveillance or a motion for discovery related to taint or an attempt to suppress, but is wholly untrue. That's not the rule of decision when you just have a free-floating discovery motion. No one says, not even plaintiff, that you could grant or deny their motion to compel discovery based on a determination of the legality of the surveillance. That just doesn't make sense. It doesn't fit with the language of the statute, either in F or in G. And secondly, just
so I was going to ask you about G. So I guess your answer to the question I asked your colleague on the other side regarding the remedies in G, when he opined that the remedies are much broader than a simple grant or denial of a suppression motion, and he pointed to language in that subsection that talked about granting or denying a motion to suppress or similar motion, that we're talking about the same categories of motions that you just described that limit the application of F. Is that fair?
That's exactly right, Your Honor. And the key point analytically is it doesn't say grant final judgment on an underlying civil claim. So you actually can't use 1806F to do that. So plaintiff's entire theory that you could adjudicate the standing and the merits of this case inside of F doesn't fit with the plain text of F for that simple reason. And then, I'm sorry, Judge Motz.
Yeah, can I ask you how your reading of 1806F, or the whole statute actually, accommodates the cause of action given in 1810?
I'd be happy to, Your Honor. So the cause of action in 1810 is linked to criminal liability in 1809. And the conference report, that's House Report 95-1720 at 34, I want to say, or maybe it's 32, says that the scope of civil liability should, quote, coincide with criminal liability under 1809. So it's clear that 1810 isn't going to be some omnibus statute that basically anyone can use to allege and challenge surveillance. And so the core application of 1810. I'm sorry.
I don't understand how anybody could use it, given your interpretation of 1806. I mean, in other words, the government can do away with any claim, according to you.
So I don't think that's quite right, Your Honor. And I just wanted to illustrate sort of why that is. The district court got it right when it said, look, 1810 actually doesn't apply against the government at all, as the Ninth Circuit is squarely held. It only applies to these sort of rogue intelligence agents in their individual capacities. And there's no reason to think that if the government were to, say, criminally prosecute an intelligence agent who were surveilling somebody without FISC authorization, that then wouldn't allow some kind of follow-on civil suit. But the other key point is that 1810 is not a promise that every litigant who tries to bring that claim will end up being able to obtain final judgment on the merits. There may be a whole host of...
You're making the distinction between civil and criminal cases, which is a happy one for you, except doesn't 1806 also refer to to civil cases?
Yes, and we've never claimed otherwise, Your Honor. So, for example, the Hamid case in the Ninth Circuit.
Is that it?
No, I actually don't think it turns on whether we initiated the lawsuit or not. It actually turns on whether we're trying to use whoever initiated it, whether it's civil or criminal. If we're trying to use information affirmatively against the person we're litigating against, that's when 1806 comes into play to determine whether we're able to do so or not. I just want to actually return to the discussion about whether this is entirely within our control, and whether plaintiffs will be able to bring civil lawsuits challenging alleged NSA surveillance. So just to finish that argument, because I think it's very important. First, when we give notice in criminally prosecuting somebody, we are telling them you were subject to surveillance. Now, if then there's a determination that surveillance was unlawful for some reason, there may be an opportunity for that criminal defendant to turn around and become a civil plaintiff and then seek.
But sir, we know from history that sometimes you don't give notice and there is surveillance. We have confessions by the Attorney General. There's a number of instances in this case that are talked about, correct?
We absolutely have.
I mean, do you want me to go find them in the brief? You don't remember those?
No, Your Honor, I'm not denying that there has been dispute about whether the government is giving.
The Attorney General of the United States confessed error.
Yes, Your Honor, and since then, the government has redoubled its efforts. And so
well, I'm glad to hear that, but still, that wasn't dispute. That was a withholding by the government that it was not permitted to do, right?
I believe that was the basis for the confession of error, Your Honor. But to return to the answer, that we have provided notice in these cases, and that's why the Ninth Circuit and the Second Circuit have addressed and upheld the constitutionality of a different type of FISA 702 surveillance, the PRISM program, in cases we cite in our briefs. But then to move on with the answer, there's the ACLU versus Clapper case in the Second Circuit, in which we actually didn't invoke the state secrets privilege when the plaintiffs there sought to challenge NSA's call detail record collection. And, standing did not prove to be an obstacle ultimately in that case. We didn't invoke the privilege. And so it's simply not true that everywhere and always we're going to invoke the state secrets privilege. That's because the privilege is not lightly invoked. We follow the Supreme Court's mandate in Reynolds that we think hard about it and use it only where necessary. Secondly, it's not a tool wholly within our arsenal. The district court stands as a gatekeeper, and it reviews our invocation and either upholds it or does not. It was upheld here properly and for very good reason, as the Barnes Declaration makes clear, the classified declaration here. And finally, the privilege is not a categorical matter in the way that plaintiffs imagine. It's simply not true that everywhere and always, in suits like these, there will be a fundamental state secrets problem. There wasn't in ACLU versus Clapper, the Second Circuit case we were just talking about. We didn't even invoke the privilege.
Excuse me, may I ask a procedural question? So you've mentioned twice the classified declaration of the Deputy Director of the NSA, I think it was, who filed that declaration, and Judge Ellis relied on it. I was just curious, so it would seem to, given the invocation of the state secrets privilege, it would seem to almost waive it if in fact you've submitted something in camera for the court to review. So can you talk about, what was the process for that?
So this is actually the traditional process followed in state secrets cases. It's very common for the government to submit a public declaration saying these categories of information are privileged because disclosure would harm the national security. And sometimes a public declaration might suffice on its own, but very frequently we will have to follow that up with an in-camera classified declaration explaining and laying out exactly why release of this information would harm the national security in grave ways by, I can't go into the details here, obviously, but the general...
Right. But my question is, isn't that the equivalent of the in-camera review that we're fighting about with respect to 1806, or is it something different?
It's something different, Your Honor. And so this court's opinions in El Masri and Sterling go into this to some degree, which is that sometimes it'll be necessary to examine some information in camera to determine if the category of information is privileged. But once you make that determination, the privileged information is removed from the case entirely, and there can't be further in-camera proceedings using the privileged information to conduct the litigation. That's antithetical to all the principles of the state secrets privilege. I think El Masri and Sterling are quite clear on that point.
Well, of course, their fundamental claim that with the media makes is that the state secrets privilege is no longer applicable. And I know that you don't agree with that, but if that was so, it is, and the court so far that seems to
Judge Motz, I don't know about you, I don't know about the lawyers, but I had a hard time hearing what you were asking.
I'm sorry. My thing is on as loud as it'll go. Can you hear me now?
It's fine now.
Yes.
Yeah, it's fine.
Okay,
now.
I'll just try to talk louder. I don't usually have a soft
No,
voice.
it wasn't that you weren't loud enough. It was just muffled for some reason.
Oh.
But you're fine now.
Okay. What I was asking you is about the claim by Wikimedia that 1806 does away with the privilege, and the fact that other courts have considered this, a number of other courts, maybe every other court that's considered this exact argument has agreed with Wikimedia.
Your Honor, the only other circuit court I'm aware of that even considers
Did I
that
say
question.
circuit court?
Sorry, Your Honor.
I said every other court. I didn't say.
Oh, I'm sorry. There was some audio problem. So I
Okay,
apologize. No, so I just want to highlight this style of argument that Wikimedia has been raising here has only lately arisen, right? This is sort of a late breaking discovery inside the FISA, starting decades after the FISA was enacted. So there's actually that much case.
I saw that in your brief, but actually there seem to be cases that are 10 or 20 years old. So I don't know that that's actually true, but go ahead.
No, so I agree. Even taking the cases that the other side cites too, I think they start in 2004, 2005. I guess my simple point is there's not too many cases on this subject. Many of those cases that they cite to, my reading of them was that the court took it as a hypothetically could be true that you could use 1806 in this contemplated way, but did not use that as a basis for resolving the claims before the court in those opinions. So I would take many of those as being dicta. In any event, I really want to address this head on because I think it's very important. Nothing in 1806F indicates that it intends to displace the state secret's privilege. First of all, El Masri makes clear that the privilege has foundations both in the common law and the Constitution. El Masri says it has.
El Masri was decided, I was there when it was decided. Maybe I was on the panel. I remember it very well. The Supreme Court has said that this is a common law privilege. And that's the law. We follow the Supreme Court, right?
Oh, no. So I don't, the Supreme Court in General Dynamics did not have an occasion to determine whether, in addition to being a common law privilege, it also has constitutional foundations.
Well, they characterized it as a common law privilege. And if it was a constitutional privilege, don't you think they would have said that?
No, Your Honor. And there's nothing that these two buckets aren't mutually they can coexist together. And so I think it's actually quite commonplace to talk about the common law when figuring out the scope of a constitutional right or obligation. We talk about that in the Fourth Amendment context quite frequently. And so there's actually nothing sort of odd about the idea that a part of the common law is also constitutionalized. And so we think El Masri has that just right. But also the Supreme Court in General Dynamics did not turn around and say, and call into question what it previously said in Egan and Nixon. In Egan, it says that the Article 2 obligations of the executive branch to protect classified national security information, that's a constitutional function of the government. And Nixon says that privileges that help the executive carry out its constitutional obligations are themselves part of the executive privilege and have a constitutional basis. That's why El Masri was right. General Dynamics says nothing to call it into question. And just to highlight, there's nothing antagonistic about saying that 1806F procedures can coexist with the privilege. Indeed, as we point out in our brief, the DC Circuit noted in the Belfield case that even before 1806F was enacted, the government's ability to use information obtained or derived from electronic surveillance was often subject to a determination in camera and ex parte, and that coexisted comfortably with the existence of the state secret's privilege because they have different scopes and different functions are invoked by different people and they do different things. 1806F is about whether we can use information against another litigant. That's why it's invoked by the Attorney General. That's the decision maker in charge of government litigation. The state secret's privilege is about removing information from a case, so it can't be used by us or anyone else, including the district court in camera. And that's invoked by the person with control over the information. And it's different scopes.
Mr. Busa, that seems a little bit inconsistent. Excuse me, a little bit inconsistent with the plain language of F, which includes among its the things that a party can do includes discovery of certain information. So How does discovery of information square with removal of information pursuant to the privilege?
Because again, that's the F procedure is where we're trying to use information against another litigant, and that person is trying to interfere.
Well, but
with our ability to do so.
government would have no need to discover information. It's got the information, so that the suggestion to discover information must mean something. It must mean that the other side, the person who doesn't have the information, is seeking to obtain it in some way.
Correct, Your Honor. And as we were discussing earlier, our view is that the best reading of that language is it's a discovery motion that's seeking to do something similar to what the suppression motion in E is seeking to do. So here it would be discovery related to the question of, say, taint from a prior unlawful surveillance, right? So the question of what scope of evidence has to be suppressed. So that's the kind of discovery motion we're talking about, something tied to the government's use of information. That's why.
Is there a case, do you have a case that stands for that proposition, or would this be the first case?
I'm not immediately aware of a case addressing that question, other than, of course, the Fazaga case, which we've discussed before in the Ninth Circuit. And I think that's because it's so rare for litigants to try to make use of this third clause, because the third clause, as the legislative history makes clear, is there in order to prohibit, quote, inventive litigants, like the plaintiff here, from trying to bypass the procedures laid out in the prior clauses. That's the first and second clause. And so, to my knowledge, there's not much litigation about what can fit within this third clause. We think all the textual indications are in our favor here. There's the title of the section. There's the fact that all the prior sections about the government's use of information, the first two clauses of 1806F are about the government's use of information. Here it says other, so it's not any motion to obtain or discover, it's any other motion that links it back to the essential features of the prior thing. And it's also what gets determined in the 1806F procedures, that's legality of surveillance. That's the rule of decision for deciding suppression and discovery attendant to suppression. It can moot that question. But it's not the rule of decision for a general discovery motion like what plaintiff has presented here. And the plain text of G and F is that the result of an F proceeding is not final judgment on the merits of a civil case. It's the grant or denial of a motion, right? So, and I think it's actually important to address something that arose in my colleague's stand-up time that I want to make sure I have a chance to address before my time is out, although I see I'm running down. So if I might have a chance to address this idea of a general verdict, maybe protecting state secrets, and it's clearly impossible in this case. First, we just went over how 1806F can't be used for adjudication to final judgment on the merits of civil claims. It just doesn't fit with the plain text of the statute. So you can't use F in that way, nor could you use the state secret's privilege, because we know from Sterling and El Nasri, you can't use privileged information ex parte and in camera. But secondly, a bottom line ruling, quote, plaintiff wins, as plaintiff here imagines, would disclose standing, and that would reveal state secrets. Secondly, because they can't get back.
Necessarily, sir, I don't think that's necessary. I thought about that. I don't think that's necessarily so. Unless you're talking about revealing it to the district court, which seems to me that your whole argument seems to this wouldn't have to reveal anything. All it has to do is to issue.
Judge Motz, you're muffled again. You're muffled again.
I'm sorry.
Yeah.
Talking the same way. Here, you'll just get. I'm afraid if I get too close, it'll be nauseating. But anyway.
No, you're fine. You're fine. Go ahead.
Anyway, I'm afraid I've lost my train of thought. But the district court isn't revealing. Do you believe that revealing things to the district court breaks the state secret? I mean, that seems to be what you're saying.
I have two responses. I'm sorry, I have two responses, Your Honor. The first is, yes, that's exactly what Sterling says. Sterling says the risk of using state secrets in camera is that it will lead to even an inadvertent disclosure outside of chambers.
Well, I don't know that says exactly yes to my question. I understand that that's a risk. But so it's the government's position here that revealing information to the district court to consider all by itself, and then to issue an opinion that may put under seal the whole thing, that is revealing a state secret.
So first of all, again, two responses. And to get the second one, yes, the
Well,
district court
would one of them
correctly.
be answered out of that question?
So yes is the answer. That would violate the state secrets privilege. El Masri and Sterling make clear you can't use privileged information in camera and ex parte because that's playing with fire, in the words of Sterling. It risks inevitably that unintentional disclosure outside of chambers, and that is too great a risk to allow. That's why this court's precedents and the Supreme Court don't allow use of privileged information to decide the merits of any case. That's been roundly rejected. But also just to highlight why, even if it were thought you could go through with that kind of in-camera procedure consistent with the state secrets privilege, even the bottom line ruling, plaintiff wins, that would necessarily disclose standing. And as the district court correctly found, the existence or non-existence of surveillance of an entity like the plaintiff here is itself a state secret that would give a roadmap to foreign adversaries, very savvy foreign adversaries who know how to read the tea leaves, as to which channels of communication are open, which are not. It would allow them to evade lawful government surveillance. It would also give them a roadmap for conducting operations against the United States. Those are all extremely grave consequences. They're discussed in detail in the classified Barnes Declaration. And so for that simple reason, even the bottom line ruling, plaintiff wins, would disclose a state secret. And of course, if plaintiff can't win, then it's got a remediability problem from the get-go in terms of standing. And so we just don't think—
One question about aggrieved status, aggrieved person. Can you become an aggrieved person under this statute in any other way than the government's definition of surveillance?
I think it would be quite difficult, and I can't think of a concrete circumstance where they'd be able to do that consistent with the privilege. But I think my answer about that, it's really impossible to state it in categorical terms because, again, the question for the privilege is whether revelation of the underlying information would pose such a harm to national security that information has to be removed from the case entirely. And that's just going to depend on the context of the case. My best pitch for you on this is just to think about ACLU versus Clapper. That's that Second Circuit 2015 case in which we did not raise the privilege. And the plaintiff there, my understanding was able to make outstanding on the basis of a public record. And so it's simply not the truth. This is a tool wholly within our toolkit. And in any event, the district court is ultimately the one that decides whether the privilege is upheld or not. And so it's not true that a civil plaintiff is at our mercy.
You have about 1 minute and 30 seconds left, and I want to give my colleagues a chance. Judge Rushing, go ahead.
I'd like to ask you, Mr. Busa, what I asked Mr. Toomey about the feasibility of inline filtering. As I mentioned, the technologist brief raises something that I didn't see either side discussing about the fact that these tier 1 ISPs wrap or encapsulate the header, and your argument for the feasibility of inline filtering seems to rely on access to the header. What's your response to that?
My two responses, one on the merits, which is that they seem to be wrong, but secondly, they don't actually, it's important that that is not an opinion from an expert offered on the record in the district court and subject to adversarial testing under 702. And so we think it's quite unfair for plaintiffs to try to be relying now on the untested assertions and sweeping conclusions drawn here without any of the underlying evidence that an expert would need to show that they're relying on in order for their opinion to be admissible as evidence, right? So I can't point you to, I'm sorry, Your Honor.
Oh, no, I was just going to clarify. So you don't think that this was raised or any evidence about this was brought in front of the district court to create a fact question there?
No, Your Honor, and certainly not in the sweeping terms that amici presented. I think it's very telling that the reply brief quotes the amici and their very sweeping conclusions, and then just says, see also some paragraphs of the Bradner Declaration, where when I read them, I don't read Mr. Bradner reaching any kind of those kinds of sweeping conclusions that amici seem to raise. And so we do think it's quite unfair for plaintiffs to be trying to inject that into the record now when it's clearly not part of the record. Secondly, just to address the merits of all of this, even amici don't say that all tier 1 ISPs do this encapsulation. So it really is a question of wherever the government is conducting surveillance, wherever that may be, is it able to do so in the method laid out as a hypothetical by our expert? And the answer, even under the amici's reading, is yes, if that's being conducted at a person who's not using this encapsulation technique. And secondly, even addressing this encapsulation point, just reading a Wikipedia article about encapsulation, ironically, it seems to me that on the merits, encapsulation happens within a certain part of a network, and there's routers that pop on and off these capsules, and there's other routers in the middle that just read the capsule heading. And so even on
We're the expert
theory,
now.
no, and that's the problem, Your Honor, is that we never had a chance.
Sir, let my colleagues ask any additional questions. You've already gotten another 3 minutes. Okay, Judge Rushing, do you have any more questions?
No, thank you, Judge Motz.
Sorry, what did you say?
I said, no, thank you, Judge Motz.
Okay. Judge Diaz?
I don't, thank you.
All right. Perhaps you can conclude your argument in 5 seconds.
We simply ask that you affirm, Your Honor. Thank you.
Thank you very much. So, Mr. Toomey, I'll give you 3 additional minutes on top of what happened, because your colleague got 3 additional minutes on top of what I've given him. Okay, thank you.
Thank you, Judge Motz. Appreciate it. Just quickly to touch on the point that Judge Rushing raised, the expert declaration does address techniques similar to the encapsulation that is discussed in the amicus brief, and that's in the first Bradner declaration at paragraphs 91, 174, and 230, which discuss the use of tunnels and NATs by providers. And those techniques wrap communications in another layer in the same way that the amicus brief.
Is that about the header? Because that's what, the government is saying it can filter based on the information in the header.
Yes, Your Honor. Yes, it is.
Are those the paragraphs that you cited in your reply brief?
I don't know that we cited those paragraphs specifically in our reply brief, Your Honor. I did want to point out that those issues were addressed in the declarations in the record.
So you're saying it's the same thing as tunneling, or it's similar enough that you put the district court on notice and that the government should have had its expert respond to that?
Yes, Your Honor. Tunneling and NATs, NATs is the other technique. But what I want to come back to some of the bigger picture questions. First, the government claims that one can find a limitation in 1806F by pointing to the 2 of the scenarios in the statute as showing that there must be clear evidence or a government admission of surveillance. But even the second prong under 1806F, which discusses when a defendant may bring a motion to suppress, does not depend on government notice. A party is aggrieved regardless of whether a defendant has received notice or a person has received notice. And so the pattern or the principle that the government is trying to draw isn't found there. The government's reliance on the word other in the statute, the government moves the word other to a place in the statute where it doesn't exist. What the third prong of 1806F refers to is other statutes or rules. And there's no ambiguity about what that means. Other statutes and rules means other than the provisions in FISA that are the subject of the preceding prongs. On the question of displacement, the statute again speaks clearly. It says notwithstanding any other law, and that encompasses the common law state secrets privilege. Now, I also want to emphasize that Congress clearly intended to encompass civil cases under 1806F, and it did not draw the type of distinction anywhere that the government claims here. It did not claim that it only applies to civil cases where suppression or admissibility is at issue. And in fact, the House report at 95, I think it's 1253, page 94, talks about the government facing a choice of having to concede litigation when a suit is brought against it. and having to face the choice of whether to concede that civil litigation or not. So all of these show that Congress's intent and the structure of the statute, including the civil remedy, Judge Motz, that you were asking about, fall within the scope of the procedure in 1806F. And Congress was explicit when the conference committee met and the House and Senate versions of FISA were reconciled that this provision, the third prong in 1806F, was being added to cover civil cases where FISA surveillance was challenged. On one further point, in terms of what a ruling in Wikimedia's favor would disclose, the government claims that it would provide a roadmap to people, to the public, but what all it would reveal is that the government's public disclosures establish Wikimedia's standing, which of course the members of the public can already examine. Scott Bradner has examined them. The other experts who filed their amicus brief have examined those disclosures and have reached the unsurprising conclusion that Wikimedia, which engages in trillions of web communications, is subject to upstream surveillance, which the government has acknowledged includes collection of web activity. And now that does not, now a ruling for Wikimedia, merely finding that it has shown it is more likely than not that some of its communications are subject to the surveillance, which is all that a ruling in Wikimedia's favor would show, would not add anything to the public record that any member of the public could not already see there.
Thank you very much. We appreciate your argument, appreciate both arguments and your excellent briefs. And we'll take the case under advisement. I'd like to ask my colleagues if they want to take a short break after this.
I'm okay with proceeding if you are.
Yeah, I'm fine. You fine too?
Yes.
Judge Rushing? Okay, fine. Thank you very much. Here. We're happy to hear argument in our second case, United States versus Hassan. Mr. McBeth?
Thank you, Your Honor, and good afternoon. My name is Cullen McBeth, and I represent the appellant, Christopher Hassan. Your Honors, in Johnson v. United States in 2015, and again in Sessions v. DiMaia in 2018, the Supreme Court made clear that a defendant may bring a facial void for vagueness challenge, even if the statute is not vague as applied to his own conduct. In both those cases, the Supreme Court struck down statutes as facially vague without considering or deciding whether the statutes were vague as applied to the particular litigants bringing the challenges. In fact, in footnote 3 of the DiMaia opinion, the majority noted that Justice Thomas, in dissent, believed that the statute was not facially vague because there were some people as to whom its application was clear, including the petitioner in that case. But the majority responded that the court had, quote, anticipated and rejected that argument in Johnson. In other words, a defendant may attack a statute as facially void for vagueness, even if there are some cases in which it is clear, such as the defendant's own case. In short, what we call the own conduct principle is no longer good law. The district court held below, and the government argues here, that Johnson and DiMaia rejected the own conduct principle only with respect to statutes that require applying the categorical approach. But nothing in those opinions suggests the Supreme Court was announcing a one-time only exception to the own conduct principle. Neither the district court, nor the government, nor any of the cases the government cites identifies any language in either Johnson or DiMaia that even arguably suggests the own conduct principle remains valid in non-categorical approach cases. And contrary to the government's argument, this court has never addressed or decided whether Johnson and DiMaia abrogated the own conduct principle. The defendants in United States v. Hosford and United States v. Morello did not argue that Johnson and DiMaia eliminated the own conduct principle. And this court, therefore, did not address that question. And as this court has said in United States v. Norman, which we cite in our brief, quote, judicial decisions do not stand as binding precedent for points that were not raised, not argued, and hence not analyzed. And so as a result, this court can consider Mr. Hassan's facial vagueness challenge to Section 922G3 on the merits. As we explain in our brief, that statute fails to provide a person of ordinary intelligence with fair notice of what conduct is prohibited. The term unlawful user of a controlled substance, as construed by this court's cases, makes liability depend on three nebulous, open-ended, and imprecise standards layered one on top of another. So according to this court, citing the Ninth Circuit's opinion in Purdy, the defendant's drug use must be consistent, prolonged, and close in time to his gun possession. And this court has found that statutes employing similar language are void for vagueness. So for instance, probably the best example is this court's opinion in the Manning case, the en banc Manning case from 2 years ago, in which the statute at issue allowed an interdiction order to be entered against someone who was found to be a, quote, habitual drunkard. And this court looked at that language and said, we don't know what that means. What does it mean to be habitual? How frequently does someone have to use alcohol? What amount of alcohol does it have to be? None of those questions are answered by the statute. And the same is true here. And
Mr. McBeth, let's assume for the moment that we don't agree with you that that your client is entitled to make the challenge as broadly as you would like it, but instead has to limit the challenge with respect to his own conduct. So what is it about the defendant's own conduct here that poses a problem with respect to his conviction?
So, Your Honor, we're not making an as-applied challenge. So for the purposes of this appeal, the court can assume that an as-applied challenge would fail. We're not, in the event that this case goes back to district court, I don't want to concede anything, but the court can operate on the assumption that there's no successful as-applied challenge here. But our position is that after Johnson and DiMaia, that just doesn't matter because in both those cases, there were dissents where a justice said very clearly, facial challenges are only appropriate if the defendant's own conduct, if the statute is vague as applied to the defendant's own conduct. And in both cases, the Supreme Court disregarded that and moved on to the merits. And in DiMaia, it did more than just disregard it. It specifically said, we anticipated and rejected that argument in Johnson. And it doesn't matter if there are some cases where the statute is clear, including the defendant's own case. So people are allowed to bring facial challenges after Johnson and DiMaia, regardless of whether their own conduct is covered. And the Ninth Circuit's opinion in Kuzma, which we cite in our 28J letter, I think adopts that position. And in my 28J, I said that the Ninth Circuit was assuming that the own conduct principle doesn't apply anymore. But having reread the opinion, I think it actually goes farther than that. I think it actually does hold the position that we're urging here, because it talks about the Johnson case, talks about DiMaia, talks about Davis, and then it drops a footnote and it says, the facial invalidations in these cases refute the government's assertion that outside the First Amendment context, only as applied vagueness challenges may be considered. So in other words, the Ninth Circuit there is noting that before Johnson, there was a limited exception to the own conduct principle for statutes that implicate First Amendment conduct.
Mr. McBeth, isn't there a difference with respect to saying on the one hand that a statute is constitutional unless it's vague and it's in all its applications, contrasted with whether or not a statute is constitutional with respect to someone's own conduct? Those are two separate things, don't you think?
So they are, but as we say in our brief, the all its applications principle is the reason for or the rationale for the own conduct principle. I mean, they were historically linked to one another, and the Supreme Court's opinion in Village of Hoffman Estates makes this clear, where it recites the all its applications principle, and it says the rationale is evident. And then it goes on to say that to succeed in a facial challenge, you have to show that the statute has no core. It can't be applied to anyone. So in other words, if you can't show the statute is vague as applied to you, you necessarily can't show that it's vague in all its applications, and therefore your facial challenge fails. So those two principles are related to one another. And now that Johnson has unambiguously discarded the all its applications principle, the own conduct principle goes with it, which again, the court recognized at least implicitly in Johnson, and I think explicitly in DiMaia when, Justice Thomas said in his dissent, this statute is clear as applied to this petitioner. In this case, it is not vague. Yes, Your Honor.
It's Judge Rushing. Isn't another principle underlying the own conduct principle the idea that constitutional rights are personal, that one you can't assert typically, except in unique cases, you can't be asserting the constitutional rights of other parties? Isn't that a separate foundation for the own conduct principle?
So certainly there are prior Supreme Court cases that gesture at that idea, but I think it doesn't they've never sort of used the word standing, but I guess that's sort of what they're gesturing at. But I think Johnson is recognizing that doesn't really make sense, because if a statute is facially vague, that means it cannot be applied to anyone. There are no cases in which it can be applied, including people as to whom it would be clear as applied. So if a statute can't be applied to anyone, then it makes sense that anyone should be able to bring a vagueness challenge against that statute. In other words, if 922G3 is in fact vague on its face, then it can't be applied to Mr. Hassan. And so because applying it to him would be illegal, would violate due process, he should be able to make that argument. I mean, the sort of alternative would produce pretty anomalous results. So, if the government is right that you have to have a successful as applied challenge in order to bring a facial challenge, then facial challenges essentially become redundant and superfluous, because if you can win an as applied challenge, then there's no reason you would bring a facial challenge, since you necessarily win anyway just by winning the as applied. And so those challenges essentially become superfluous. And even if someone does bring one, suppose someone other than Mr. Hassan brings a facial and as applied challenge, and the court holds that both are successful. At that point, the statute is void for vagueness on its face, and it can't be applied to anyone, including Mr. Hassan. And so we end up at the same place as if Mr. Hassan had brought the challenge, except that the only way we got there is that some unknown third party, unforeseen to Mr. Hassan, happened to bring a facial vagueness challenge that succeeded. And so in that case, the applicability of the statute turns on some fortuity about who has and hasn't brought a challenge before him, which seems like a very odd system. I mean, there's no logical reason to structure challenges that way. So again, to the extent that the sort of standing aspect of this was, an essential element of the own conduct principle, the Supreme Court would have been aware of that in Johnson and DiMaia, and it nevertheless proceeded to strike down those statutes as facially vague. If I could, I'd like to turn for a minute to the terrorism enhancements. For the reasons we explained in our reply brief, we think we did adequately preserve this claim, and I'm happy to talk about that. But I think the more important point I'd like to make is that even if the court concludes that this claim was not preserved below and therefore plain error applies, we are still entitled to relief because the error in this case was plain. This is a clear case of interpreting statutory text in the 1996 directive. And that directive says that the commission should amend the guidelines so that the enhancement only applies to federal crimes of terrorism. A federal crime of terrorism, in turn, is defined as, quote, an offense that is a violation of an enumerated statute. So you put those two parts together, and what you get is the enhancement only applies to a violation that is an offense, to an offense that is a violation of an enumerated statute. So if the defendant's offense is not a violation of one of those statutes, the enhancement cannot apply. And yet the commission we're assuming for this appeal, the commission wrote the enhancement in such a way that it does reach people whose offenses are not violations of enumerated statutes. And that is flatly inconsistent with the text of the 1996 directive. There's just, there's no way to reconcile what the commission did with what Congress told the commission to do. And to the extent the court thinks the text of the 1996 directive is at all ambiguous, the legislative history dispels the ambiguity entirely. The final conference report for EDPA says in crystal clear terms that the commission is supposed to amend the guidelines so that the enhancement only applies to the listed crimes upon conviction for one of those crimes. And the commission obviously wrote the guideline more broadly than that. Mr. Hassan has not been—
Mr. McBeth, I'm sorry, I missed that. Where is that? Where do you say that is?
That's in the final conference report that was prepared before EDPA's passage, which we cite in our brief, where the conference report says we are amending this guideline or directing the commission to amend the guidelines so that it only applies— sorry, Your Honor, I'll find the exact language. It says, this section of the bill would make this guideline applicable only to those specifically listed federal crimes of terrorism upon conviction of those crimes. I mean, it's plain as day in the legislative history that Congress wanted a conviction for one of these crimes to be a predicate for application of the enhancement. And the government doesn't disagree with that. Their response brief makes absolutely no argument on the merits as to how this guideline is consistent with the text of the congressional directive. And, even putting aside the legislative history, again, the statutory text is clear. It says it only applies to an offense that is a violation of one of these statutes. And here, none of Mr. Hassan's offenses was a violation of an enumerated statute. And nonetheless, the district court applied the enhancement. So that is erroneous. It's plainly so. There's no way to reconcile with what the commission did with the 1996 directive. And for that reason, the error is plain. And as we explain in our brief, the district court explicitly declined to say that it would have imposed the same sentence. So on plain error, that means that the third and fourth prongs of the plain error test are satisfied under Molina-Martinez and Rosales-Morales.
Mr. McBeth, if we have to resort to a Senate conference report to divine what the intent of Congress was, that suggests that the language is less than clear, subject to some ambiguity. And if that's the case, why wouldn't we give some level of deference to how the commission interpreted it in revising the guideline?
So you don't have to resort to the conference report. So I think the text is very clear. The 1996 directive says this guidelines should be amended so that the enhancement only applies to federal crimes of terrorism, as defined in 2332B. And then 2332B defines a federal crime of terrorism as, quote, an offense that is a violation of a certain statute. So in other words, put the two parts next to each other, what you get is the enhancement only applies to an offense that is a violation of these statutes. And I think that is very clear. I don't know how you could read that language to permit the commission to apply the guideline to people whose offenses are not violations of one of those statutes.
Wasn't the primary purpose, or at least one of the purposes of Congress in this amendment, was to capture the increasing levels of domestic terrorism and make it clear that the statute and the accompanying guideline would reflect that defendants would be on the hook for both domestic and international crimes of terrorism, and not, that seems logical. And why would they then change the language that had been in existence for a good bit of time with respect to simply promoting those crimes without the need for a conviction? Why would that follow from that purpose?
Well, so there is additional legislative history which is discussed in the dissent in the Graham case from the Sixth Circuit, in which Congress talks about how they realize that the term terrorism or terrorist is a very serious term to be attaching to someone. And so they actually want to be very careful about attaching that to someone unless the conduct in question really is terrorist conduct. This is in the, I believe it's in the House report to EDPA, which we don't cite in our brief, but it's discussed in the Graham case. But anyway, in any event, even if that wasn't their purpose, that still cannot override the plain text. I mean, to go back to the point that you were just making, Judge Diaz, if we have to resort to the purpose of Congress, then that can't override the text. The text here says it only applies to an offense that is a violation of an enumerated statute, and the Commission violated that direct order. If the enhancement is applying to people whose offenses are not violations of an enumerated statute, then it is inconsistent with what Congress ordered in the 1996 directive. And I see I'm running out of time, so if I may, I'd like to reserve the rest of my time for rebuttal.
I think you're 2 minutes over.
Yes, out of 16, but I'm sorry, Your Honor, I will stop there.
Thank you. Mr. Wyndham?
Thank you, Your Honor, and may it please the court. The defendant asks this panel to throw away decades of precedential and persuasive case law, to chart its own course, and to create a circuit split in 3 different, unique ways. First, the defendant would have the court disregard decades of Supreme Court jurisprudence and do away with the own conduct principle. Second, the defendant would have the court strike down a federal criminal statute, 18 U.S.C. 922 G3, that has been upheld by other courts to have considered the issue. And third, the defendant would have the court invalidate application of a sentencing guideline that has been applied in this circuit and others based on the district court's proper understanding. The court should disregard the defendant's invitation and should affirm the district court. I'd like to start on the first issue with respect to the facial vagueness challenge to the section 922 G3 statute. The defendant simply cannot mount the facial challenge. The defense claims that it can bring the facial challenge based on Johnson. But for more than 50 years, the Supreme Court has ensured the defendant whose conduct falls squarely within the prohibitions of a statute cannot make a facial vagueness challenge. Here, as we heard the defense state, and which was not contested below, the defendant's conduct falls squarely within the statute. So the defense's argument in attempting to dismiss the longstanding own conduct principle is that Johnson has undone the all its applications principle, and that the all its applications principle was the only rationale undergirding the separate own conduct principle. The defendant is wrong for a few different reasons. Some of these reasons, Judge Rushing, you touched on, and Judge King, one of your questions, touched on. But first, I'd like to start with the fact that Johnson never claimed to make a broad pronouncement regarding the own conduct principle. 6 years ago, as the court well knows, Johnson held that the residual clause of the Armed Career Criminal Act was unconstitutionally vague. Nowhere did it say, and nowhere did it apply, anything at all about the own conduct principle. That principle simply was not before the court, and as the defense acknowledges, it is a different principle than the all its applications principle. Indeed, the defendant in that case does not appear to be one whose conduct clearly fell within the prohibited range, such that the own conduct principle would even come into play. And certainly none of the 4 opinions in that case touched on. The defense admits in its brief at page 31 and 32 that at least 7 separate Supreme Court opinions going back to the 1960s discuss and rely on the own conduct principle. Presumably, the Supreme Court would have said something if it had intended to overrule several presidential opinions. And as the court knows, it is the Supreme Court's prerogative alone, not this court's prerogative, to overrule Supreme Court precedent. I will note also in Johnson, at the end of it, the Supreme Court expressly overruled 2 other cases that were in the all its applications line, but said nothing about any of the other 7 cases in its past regarding the own conduct principle. So that's the first reason as to why Johnson does not implicate the own conduct principle. But the second reason is that the own conduct principle is not so interrelated with the all its application notion that the former falls without the latter. The defense's argument that the 2 are essentially the same is reliant on a footnote in the Village of Hoffman case that predates Johnson by 33 years to argue that the own conduct principle is inextricably tied to the all its application principle. but other Supreme Court cases, including Broderick versus Oklahoma from 1975, discuss the more expansive rationale for the unconduct principle. And I would also point the court to this court's decision in Maciandero in 2011, 638 F3rd 458, which discusses Broderick, which discusses the rationale for the unconduct principle. And essentially, it expands on what Judge Rushing noted a moment ago, that essentially individual people that essentially individual people individual defendants can assert their own rights, but not other people's rights. But the language that Broderick uses says that the conclusion reflects that the conviction that under our constitutional system, courts are not roving commissions assigned to pass judgment on the validity of the nation's laws. And it's that language that shows up in other Supreme Court cases and in repeat Fourth Circuit case law, including the Maciandero case. And so that's a separate rationale that is separate from the all its applications principle as to why the unconduct principle applies. Now, this court has relied on the validity of the unconduct principle after Johnson. If Johnson really had been such a sea change, undoubtedly those two panels would have observed that sea change. The panel in Hosford in 2016, on which you sat, Judge Diaz, published an opinion relying on the unconduct principle to reach its conclusion that the defendant could not mount a facial vagueness challenge to Section 922A1A's prohibition against unlicensed firearm dealing. And then just a few months ago, the panel in Moriello, on which you sat, Judge Motz, also relied on the unconduct principle to reach its conclusion that the defendant could not mount a facial vagueness challenge to the administrative regulations under which she had been convicted. So this court in general should follow the Moriello panel and the Hosford panel in declining the defendant's attempts to take us beyond the facts of this case. Now, I will say that on the specific point of 922G3's 922G3 and the unconduct principle, two other circuit courts have post-Johnson published opinions saying that the unconduct principle still survives. Those are cited and discussed extensively in the briefs. United States versus Cook in the Seventh Circuit, United States versus Bramer in the Eighth Circuit. And if I can just touch briefly on the case that the defense cited in the 28J letter regarding out of the Ninth Circuit from last year. That case, and the defense noted, I believe, a small portion, maybe a footnote of that opinion, which implied otherwise. But that case was predated by the Ninth Circuit case in 2019, Casham versus Barr, where the parties actually briefed whether or not the unconduct principle survived Johnson. And in that case, the Ninth Circuit held that the unconduct principle does in fact survive Johnson. That's 941 F3rd 358. So in summary, with respect to this point, the Supreme Court never said that Johnson should be read so broadly. No court has read it so broadly. And the Fourth Circuit on multiple occasions has relied on the unconduct principle surviving Johnson. Moving to, unless your honors would like to hear discussion as to why 922G3 itself is not unconstitutionally vague, I'd like to move to the 3A1.4 issue for the terrorism enhancement. The defense here, and the parties have briefed this, the defense never raised this issue below. We contend that the defense has invited the error. At the very least, it seems that the defense agrees, based on the argument today, that plain error applies. I'll stick with arguing on plain error while not conceding the invited error issue. In order to prove plain error, the defense would have to show that an error occurred, that the error was plain, and then the other two parts regarding substantial rights, and then the court's discretion as to whether or not the error seriously affected the proceedings below. Here, there was no error at all, and the error, if there was any, was not plain. I'd start with the 1994 Violent Crime Control and Law Enforcement Act, which is discussed in the opening brief of the appellant. And in that case, the
Mr. Wyndham, I'm sorry, can I ask a question about the standard of review? And I don't want to beat this dead horse, but you do concede that the defendant in this case made the general claim below that the enhancement shouldn't apply to him. He didn't make this precise argument, but he did lodge an objection to the application of the enhancement. Is that fair?
Yes, Your Honor, that is fair. The defense below argued that as a legal matter, the enhancement should not apply to him because somebody, whether it was the defendant or somebody else, should have been convicted of a federal crime of terrorism. And then also the defense made the argument below that it should not factually apply to him. However, our argument with respect to invited error is somewhat different than the Robinson case that the defense relies on as to why this claim was preserved below. In Robinson, which was a case regarding an error in the calculation of the criminal history, the defense appears simply not to have made the argument at all, though it challenged generally the criminal history. Here, the defense affirmatively argued the opposite to the district court. And in this court, it appears that the defense is arguing that 3A1.4 is a nullity, should simply not exist because of the 1996 directive. So I think that for those reasons, the standard of review, if we have it, should be that the court should not hear this at all. But otherwise, that plain error should apply because not just it wasn't raised below, but the defense affirmatively argued the opposite in both writing.
Well, just humor me for a moment, but if we think that we should just consider this issue de novo, you're ready to defend the statute on its merits, regardless of the standard. Is that fair?
That's exactly right, and I would like to do so right now. I was doing so under the context of saying that there's no error even under the plain error standard, but even under de novo review, here I would point to a few things that are discussed in the defense brief, but some of which leave out some of the definitions of international terrorism and federal crimes of terrorism. So in 1994, in the Violent Crime Control and Law Enforcement Act, that is where Congress directed the Sentencing Commission to amend the guidelines to provide an enhancement for any felony, whether committed within or outside the United States, that involves or is intended to promote international terrorism. Now, at the time, international terrorism was defined in the guidelines as 18 U.S.C. 2331, that's the definition in that statute, as violent acts or acts dangerous to human life that are a violation of any federal or state criminal law that appear to be intended to intimidate or coerce a civilian population, to influence the policy of a government by intimidation or coercion, or to affect governmental conduct through assassination or kidnapping. And third, to occur primarily outside the United States or to transcend national boundaries. So that's an extensive definition for allowing as a predicate the promotion of any crime at all, but it limits it geographically to outside of the United States. And it also discusses the coercion of the civilian population. Now, the definition of federal crime of terrorism is different. And in 1995, the Sentencing Commission promulgated the guideline which discussed intending to promote international terrorism. But in 1996, what Congress said, and this is where use of the word only, I think, becomes clear, asked the Sentencing Commission, directed the Sentencing Commission to amend the guidelines so that 3A1.4 relating to international terrorism only applies to a federal crime of terrorism. So what does federal crime of terrorism mean? It is not simply that now it used to be international and now it's not international. Though federal crime of terrorism expands geographically the definition of what falls within 3A1.4, it also narrows the ban to some extent. So first of all, instead of it simply the underlying crime simply being involving or intending to promote any crime whatsoever, federal or state, it had to apply to certain enumerated statutes under 18 U.S.C. 2332b, subsection G5. And second, whereas international terrorism had as one of its core purposes the coercion of a civilian population, federal crimes of terrorism are focused on governmental conduct under that statute and strip out the civilian population piece. So for those reasons, under the 1996 directive, the guideline could only be applied where the conduct involved or intended to promote an enumerated statute and also removed the coercion of the civilian population language. So with respect to the defense's point, if Congress had meant otherwise and had meant to actually change what was already being applied in terms of intending to promote language, it would have said otherwise. That guideline was in existence in 1995 when Congress then in 1996 passed IDFA. Now, if I could recommend to your honors that you review application note 4 to 381.4, because I think that neatly summarizes what Congress did and what the Sentencing Commission believed could happen in those situations. So as the commission understood it, Congress was directing that 381.4 not apply to cases in which the offense was calculated to intimidate the government, but did not involve an enumerated statute, or where the defendant committed an enumerated statute, but the purpose was to intimidate a civilian population. So basically, what the Sentencing Commission in application note 4 expressly discusses is the situations that the 1996 directive stripped out. And what the Sentencing Commission says in that application note is that 301.4 no longer applies to those situations, does not apply to those situations. An upward departure might be warranted under the facts, but 301.4 does not apply. So on the plain language of the directive, for those reasons, it should uphold any standard of review. And here I did note in the briefs that the Fourth Circuit has applied 381.4 in the Bencala case in 2008, where the defendant was not convicted of a federal crime.
Mr. Wyndham, your colleague on the other side referenced a Senate conference report that seemed to align with his view of the statute, understanding that we wouldn't necessarily need to look there if we were satisfied that the language of the statute itself was clear. What do you make of that language?
I think first, as a general rule of construction, you look to the plain language of the statute, Your Honor, and what we heard the defense concede today is that the language in the statute alone is plain. And so for that reason, I don't think that the court should resort to the conference report. I guess if the court does think that there's any ambiguity, the court could look to the conference report, and as Your Honor indicated earlier, to the commission's promulgation of the guideline to see what the commission believed it meant. But I don't believe that the different language in the conference report, which talks about, I wouldn't say it's as clear, and this is at the appellant's brief at page 56 is where the appellant cites the language. I wouldn't say it's as clear as the defense contends it is with respect to the conviction. It discusses expanding the scope of 381.4, whereas I've just discussed a moment ago, it does expand it geographically, but it does not expand it in terms of the crimes to which it can be applied, the enumerated statutes, and the underlying intention of the defendant to intimidate civilian populations. The last piece with respect to 381.4, Your Honors, is the clear error, is that the defense contends that the district court committed clear error. For the reasons that we cite in our brief, we simply do not believe that's the case. This was hundreds of pages of briefing, a full-day argument, extensive testimony, extensive cross-examination, and an extensive colloquy by the seasoned jurist on the bench who simply believed that the defense expert was not credible and cited the reasons why he believed that to be the case. If the court has no questions, I can't see Judge Rushing, but I wanted to post that as well. But if the court has other questions, I'm happy to answer them. But otherwise, I would yield the rest of my time.
Thank you. I don't think we have any further questions.
Thank you, Your Honor.
Thank you, Your Honors. A couple quick points. First is the government says that the plain language of the directive should govern here, and I completely agree with that. And the language is completely plain. It says the enhancement only applies to a federal crime of terrorism, which is an offense that is a violation of an enumerated statute. That is plain. The government has no response to the plainness of that language. If the defendant's offense is not a violation of an enumerated statute, the enhancement cannot apply, period. It is, whether the review is plain error or de novo, it is clear as day that in the statute, the text of the statute, Congress is saying this only applies to offenses that are violations of enumerated statutes. There's no way to reconcile that with what the commission wrote. Second, to go back to a question that Judge Diaz asked earlier about shouldn't we give some discretion to the Sentencing Commission to implement what it thinks is the most reasonable view of this language? The Sentencing Commission, in its reason for the amendment in 1996, said that it itself believed and agreed that the term federal crime of terrorism is broader than international terrorism. So the commission agreed that federal crime of terrorism is broader. Now, if the commission believed that, then if it is using, then its use of the word, Congress's use of the word only in the statute is doing nothing. Because if federal crime of terrorism is broader than international terrorism, it makes no sense to say that the enhancement only applies to the broader category of crimes. That's illogical. You would use the word only to describe the narrower category of crimes, but the commission itself has agreed the federal crime of terrorism is broader. And so they effectively stripped the word only in the directive of any meaning whatsoever. To go back to the conference report, this court and many others have said that the conference report, final conference report for a bill is the most reliable evidence of the statute's meaning after the text itself, because it has to be agreed to by members of both houses and the conference committee and represents the considered view of both houses. And I honestly don't see what part of this report is ambiguous. The government says it's ambiguous, but it clearly says this section of the bill will make the enhancement applicable only to those specifically listed federal crimes of terrorism upon conviction of those crimes. I don't know how it could be any clearer, Your Honor. Even without that, though, the plain text of the directive makes it clear it cannot apply unless the defendant's offense is a violation of an enumerated statute. And finally, just to go back quickly to the vagueness issue, the government says that in Johnson, nobody raised the question of the own conduct principle, but that's not true. Justice Alito in his dissent said at some length that we cannot strike down a statute as facially vague if it's not vague as applied to the particular party. And the Supreme Court presumably read Justice Alito's opinion and disagreed. And even if this court thinks that sort of implicit rejection of that argument is not enough, in DiMaia, which opposing counsel did not talk about at all, the rejection was explicit. The majority says, we note that Justice Thomas is saying that you can't strike this statute down as facially vague because it's not vague applied here. And the majority says, no, we already anticipated and rejected that argument in Johnson. It doesn't matter if there are some cases, including the defendant's own case, in which the statute is not vague as applied. We strike the statute down anyway, regardless of that, because again, if a statute is vague on its face, that means it cannot be applied to anyone. It can't be applied even to people as to whom it's clear. So it makes sense that someone like a defendant who, let's say, does not, is not vague in his case, can bring that challenge because it would be illegal to apply it to him if the statute is in fact vague on its face. And I see I'm out of time, so unless the court has any further questions, I'll stop there.
Now, we appreciate both of your arguments, and I think we're ready to go on to our next case.
Thank you.
Thank you. I'm Diana Motz, and Judge Diaz, you can see, and Judge Rushing, you can't see, but she's very much with us. And we're happy to hear your argument in number 204199. Mr. Bryant?
Thank you. Good afternoon, Your Honors. May it please the court. Patrick Bryant on behalf of Kelly Miltier. This court should vacate Mr. Miltier's sentence because the district court should have applied a 2-point reduction to his offense level under the sentencing guidelines. There are 3 reasons that it should have done so. First, the actions on the part of law enforcement taking material out of Mr. Miltier's computer should not be included in his relevant conduct. Second, the structure, purpose, and history of the guidelines, as well as analogous cases from this court, suggest that any distribution that would disqualify the defendant from the enhancement has to be knowing. And then third, the government's argument does violence to the structure and purpose of the guideline by rendering part of it superfluous in that it would never apply in a case involving a peer-to-peer network. So first, turning to my relevant conduct point, unintentional actions on the part of Mr. Miltier should not be included in his relevant conduct. What we really have here is conduct by law enforcement to take material out of his computer. This court has squarely held, the language is black and white, that relevant conduct under the guidelines must be criminal conduct. And the government's action taking material out of his computer is not a criminal activity on the part of Mr. Miltier. And if you look at guideline 1B 1.3, the relevant conduct guideline, the language that it uses are words like committed, aided and abetted, counseled, commanded, procured, willfully caused. All of those words, even if you include omissions, all of those words imply some sort of intentionality and conscious choice on the part of the defendant that we don't have here. It's really no different than if hackers outside, if he didn't have any peer-to-peer software at all, and hackers had broken into his computer and taken material out. That's not distribution on his part. So it shouldn't be included in his relevant conduct at all. Judge Diaz.
Mr. Bryant, can I ask a question? So did I understand you to be arguing that the reduction should apply because to the extent that there was any distribution, well, you're arguing that it was unknowing, but then you seem to suggest that because the distribution, if any, that occurred in this case was at the hands of federal agents, that's yet another reason why this reduction should apply. But I didn't take your brief to have made that second argument.
Well, our brief argues that it has to be relevant conduct. And so we've made arguments premised on the Dove case from this court and the Dura case from the Third Circuit that it has to be criminal conduct on the defendant's part in order to be relevant conduct to be considered for purposes of the guidelines at all. So we believe that is in the brief. I'm perhaps offering a different analogy for the first time today, but we certainly have made the argument in the brief that the relevant conduct has to be criminal conduct on Mr. Miltier's part in order for actions to be considered in the guidelines at all, or certainly in disqualifying him from this reduction. Because the only way he would be disqualified from the reduction is if his conduct is not limited to receipt or solicitation. That is premised that there has to be some conduct on his part. And the way that we determine that is to look at relevant conduct. So I think that is in line with the argument that we've made in the brief. If I've perhaps clarified it this morning, I'd be happy to answer any further questions you have. But I think it is consistent with arguments that we made both below and in the brief that it necessarily has to be criminal conduct and nothing. And the only conduct that happened here in terms of distribution was really the government taking it rather than Mr. Miltier sending it. Yes, Judge Rushing.
This is Judge Rushing. The criminal conduct, isn't it the conduct of which he was convicted, the conduct which he pled guilty was receipt of this material, and then it's relevant that as part of that crime, he made it available to others. He doesn't have to be convicted of distributing it. The guideline doesn't refer to distribution. This is not a case like Dove where it's a completely separate, conduct that happened on a different day in a different place. We're talking about exactly what happened, the conduct of the crime, and a relevant part of that is that he made this material available to others.
Well, I think that brings into our second point that that conduct has to be knowing on his part, or else his conduct is truly limited to receipt or solicitation. So all of his illegal activities, his knowing illegal activities, are already considered as part of the guideline. That's the whole reason that we're under this guideline in the first place. Excuse me. So there is a general presumption in the criminal law in favor of a mens rea and against strict liability. So that's the first proposition for why this should require knowing conduct on his part to take it out of the reduction. Second, the commission made clear in enacting this provision that defendants in this situation who used peer-to-peer software but did not actively send it would generally fall under this reduction and get the reduction. That's because the commission, and it said very clearly in the text of the reasons for Amendment 664, were that it wanted to more normalize the sentences and to draw distinctions between categories of offenders. And so in the commission's view, people who were convicted of what it called simple receipt were closer to defendants who were convicted of simple possession than defendants who were convicted of actual distribution. And the commission enacted this reduction in order to make that happen and to draw those distinctions. And then next, the government's position is inconsistent with this court's holding in Layton. And Layton dealt with the distribution enhancement and said that that distribution had to be knowing. And while that's a different provision, our reading of this reduction would treat the word distribution the same throughout the guideline, and it would recognize what this court did recognize in Layton and what the commission has recognized.
Mr.
I'm sorry.
Bryant,
Yes.
sorry to interrupt, but
No.
just to clarify, the word distribution is not in B1B.
That's correct, but the basis of the district court's decision was that Mr. Miltier engaged in distribution simply by having this software on his computer. And so that's the reason that the court gave for denying the reduction, was a finding that he had engaged in distribution. And so that's why it's relevant. But the more fundamental part of why Layton is relevant and why the government's argument is really inconsistent with Layton is that what this court and the commission have both recognized is that the facts matter in these cases, and that all of these software programs are different and technology changes over time. And so it's really not proper to apply a blanket rule that the mere presence of this software on someone's computer renders them liable or takes them out of this reduction, or in Layton, made the distribution enhancement applicable. And so what district courts have to do is to look at the facts and see what the evidence is about whether the defendant actually did engage in some activity beyond mere receipt. And it's not enough that this program is simply on the computer if there's no evidence that the defendant took some additional steps or engaged in additional activity. And so the reason that the government's argument really it doesn't make sense in terms of the overall structure and purpose of the guideline is it renders Part C of the reduction completely superfluous. Like I said, the government would apply essentially a per se rule that any time a defendant had a peer-to-peer file sharing software, that they could never get the reduction. And then that would make C irrelevant because it would mean that the defendant's intent never mattered. And so this court should reject any reading of the guidelines that renders part of it a nullity. But also we can demonstrate that our reading, contrary to what the government has suggested, our reading leaves Part C to do some work. So for example, in a case where a defendant is advertising pornography, say that a defendant says, if you send me material, I'll send you some. But if the defendant advertises, I have all this stuff, but doesn't have an actual intent to do it. It's so to speak, a false advertisement. That would be a situation where even though the defendant lacked the intent to do anything more than receive or solicit the material, that defendant would be disqualified from the reduction because his actions would be more than receipt or solicitation. Another example would be an enticement case. So one of the cases the government cited which I forget at the moment, is one where the defendant sent nude images of himself to a minor, and the court found that that was enticement, even though it was not child sexual material, and so therefore it was not actual distribution of that material. It was enticement, and so the defendant's conduct was not limited to receipt or solicitation. So that's a situation that, under our reading, all parts of the guideline would actually be doing work and would matter, whereas under the government's reading, the intent prong would never matter, and it would collapse the entire structure of the guideline and really go against what the commission intended, to make these kinds of distinctions among types of offenders. And then the one last
Mr. Bryant,
yes.
The government in its brief did sort of rejected that analysis by suggesting that the subsection C does some necessary work, because without that intent element there, it would necessarily cancel out the ability of the government to apply the comparable two-level enhancement that would otherwise apply in cases like this. Did you recall that portion of the brief, government's brief?
It's escaping me at the moment. Perhaps I can deal with it on rebuttal.
Okay, fair enough.
But I think that in reality, even if there might be occasional circumstances where under the government's theory it might apply, in the run-of-the-mill case, which I think this is, the run-of-the-mill case where a defendant has this software but is not doing anything more than receiving, it really would make the intent prong irrelevant. So the last thing I'd like to turn to before yielding my time is the government in its brief.
And
Yes,
just so that you know, what I was looking at, the paragraph I was looking at is at page 14 and 15 of the government's brief. So when you sit down, take a look at that, and then you can respond when you come back.
I will, Your Honor. Thank you for that opportunity. The last thing I'll mention in the time I have now is that the government cited a handful of cases from other circuits that have rejected our proposition. And I would urge the court not to treat those as very persuasive for a couple of reasons. One, none of them have any real deep analysis. They're pretty bare bones. Second, a lot of those are distinguishable on the facts, because those defendants either admitted to knowledge of the capabilities of their peer-to-peer software, or there was some other evidence in the record about things that the defendants had done that really indicated that their actions were somewhat beyond receipt. But then finally, several of those cases, I think the one that probably has the most analysis is Shepard from the Sixth Circuit, where the problem is that those cases predated the amendment that resolved the circuit split that this court took sides in with Layton. And what those courts were saying is that merely having this software equaled distribution, and that therefore his actions were not limited to mere receipt. His conduct was something beyond mere receipt. And so because those courts applied a definition of distribution that this court rejected and that the commission later rejected, those courts should not be persuasive on this question in a different guideline. Unless the court has more questions now, I'll turn it over to my friend, Ms. Bashar.
Thank you very much. Ms. Bashar?
Good afternoon, and may it please the court. Jacqueline Bashara for the United States. I'd like to begin with my friend on the other side has introduced what sounds like a new argument about the fact that the recipients of the downloads here were law enforcement officers. He suggests that that should be some kind of salient factor, that illustrates that this was not conduct attributable to the defendant. The court, I'd like to bring to the court's attention the fact that the Second Circuit in Blow, the Sixth Circuit in Abring, and the Eighth Circuit in Haney all upheld denial of the reduction based on identical fact patterns, where the only evidence of distribution was via a peer-to-peer file sharing program, where law enforcement officers were the ones who were downloading from the defendant's computer. So further, the guideline makes no distinction between at all as to whom the recipient is of the conduct that exceeds receipt or solicitation. So that really has no bearing. Now, to go into the issue of what was the defendant's relevant conduct, as Judge Rushing flagged, we start with the defendant's offense of conviction. Here, he was convicted of receipt and possession. And so 1B1.3 tells us that we look at the acts and omissions that constitute that offense. Specifically, he used a peer-to-peer file sharing program to download images of child pornography. And as a consequence, a harm that flowed from that act was subsequent distributions of those images. And 1B1.3A3 tells us that that harm that flows from the act constituting his offense of conviction is properly considered as relevant conduct. So there is no dove problem in this case. So next, my colleague, sorry, was there a question?
Yeah.
Sorry, Ms. Bashir, I do have a question.
All right.
So that relevant conduct analysis would apply regardless of the circumstances by which the transmission occurred. So, for example, let's say a defendant didn't receive the pornography via a peer-to-peer network, but instead simply received it locally and then downloaded it to his computer, and then his computer gets hacked. And that hack results in a transmission or distribution of the pornography. That would be the same result?
Yes, Your Honor. Our position is that even unknowing or an unintended distribution causes an additional harm to the victims, the children depicted in these images, such that that is conduct that exceeds receipt or solicitation.
So, and what triggers all of that is the fact of the initial offense, right? Because generally the government wouldn't prosecute a individual who, for example, someone hacked into his or her computer and inserted child pornography in the computer without the defendant's knowledge. That's different, right? But
That's
it's
correct.
the nature of the, yeah, go ahead.
I apologize for interrupting. Essentially, what this court has said in other contexts involving guidelines that don't require the defendant to have knowledge of some kind of aggravating circumstance in order for an enhancement to apply is that, getting to my colleague's discussion of the presumption in favor of scienter, essentially the concerns animating that presumption are not implicated when it comes to the guidelines, because the guidelines only come into play after a defendant has already been convicted of unlawful conduct, right? So once a defendant undertakes some unlawful course of activity, he assumes the risk of the unintended consequences of that criminal behavior. So I can turn to a discussion of the commission's intent if that would be helpful to the court at this point. My colleague, of course, flagged the statement in the 2004 reasons for the amendment. However, the commission's later in time conduct in amending 2G 2.2 illustrates that the commission, in fact, did not intend for this reduction provision to carry an additional mental state requirement in prong B. And there's a couple reasons for that. First, the commission specifically amended the general distribution enhancement in 3B7 or 3BF, I apologize, but it did not amend this reduction, as the court is well aware. Further, the commission actually went outside of this particular guideline and it amended two general distribution enhancements in two other guideline provisions. Specifically, those were in 2G 2.1 and 2G 3.1. Those also provide for enhancements based on conduct involving distribution. And there, the commission elected to add a knowledge requirement, but again, it did not impose any knowledge requirement in prong B here. Finally, the commission made those conscious decisions after the Sixth Circuit had reached its decision in Abring and the 10th Circuit had reached its decision in Ray. the Commission specifically mentioned and discussed Ray in its reasons for the 2016 amendment. So we presume that it was aware of that judicial interpretation of this reduction when it elected not to add a knowledge requirement. Next, my colleague brought up this court's decision in Layton, which, as the court well knows, was construing the previous version of the general distribution enhancement. As my colleague recognized, that's a different provision. There is no indication that the Commission intended for the enhancement and the reduction to operate as reciprocal provisions. They are structured completely differently, such that it is not a case where one statute or one provision is parallel to another and it would make sense to carry over an interpretation. And they also, as the court is aware, reach different forms of conduct. The distribution enhancement covers only distribution, but the reduction reaches beyond that. It covers any conduct that is not limited to receipt or solicitation. And finally, I'll flag that my friend on the other side suggested that by imputing a knowledge requirement into prong B, that would somehow make a consistent reading of all of the distribution provisions in 2G 2.2, but that's actually not correct, because if we look at the general definition of distribution in the application notes, there is no knowledge requirement there. The Commission has left that in place over the course of several amendments. So it would actually be introducing sort of an irregularity by requiring knowledge in prong B and then a lack of intent in prong C. Finally, I'll touch on the superfluity argument. It's important to remember that prongs B and C are serving two different functions here, right? They're taking account of different things. So prong C is assessing the defendant's intent, but prong B is looking at the scope of his conduct and by implication, the amount of harm that he has caused. So yes, the defendant is correct that failure to satisfy all three prongs, if a defendant doesn't meet one of those prongs, that's enough to defeat eligibility for the reduction. But under the defendant's reading, what would happen is that so long as he satisfied either prong B or C, he would be entitled to the reduction. And that just, it's clear, both parties have agreed that all three prongs must be satisfied, and there's no suggestion that the Commission intended for prongs B and C to be interchangeable or collapsible in any way. Unless the court has any further questions, we ask that you affirm.
Thank you very much. We appreciate your argument. Counsel, do you have any rebuttal? Mr. Bryant?
Just a couple of brief points, Your Honor. First, in response to Judge Diaz's question about whether our interpretation renders part of the guidelines superfluous, I'll point the court to page 4 of our reply brief, but I think that what the government, as I understand that argument, is saying that Part C would apply. The reason that Part C is in there for the government is that someone who tried but failed to distribute material would be disqualified because they still met the intent prong. The way that I read it, I think that person would be disqualified even under B, even if C didn't exist, because under B, that would be conduct that is not limited to receipt. That sort of attempted distribution, or even perhaps possession with intent to distribute, even if they don't actually attempt to do it. So I think that's the best answer I could give in the time I have. I do want to very briefly just respond to the cases that the government mentioned. Without really getting into the weeds, I'll just say that the Haney case was a 10th Circuit case that arose in the 2255 context. So I think it's just so removed because it was an ineffective assistance of counsel argument that it's not really that analogous. The Blau case from, I believe, the 2nd Circuit took such a very broad reading that anything, including, it basically said that the mere presence of this peer-to-peer software was enough to relate to distribution, And that reading, I think, is so broad that it would apply to mere ownership of a computer. Mere ownership of the material would relate to its distribution by another party. And then the Abring case that the government mentioned, I forget which circuit that was, but in that one, the defendant tried but failed to disable the sharing function of the peer-to-peer software program. So that evinces a knowledge on the part of the defendant about the capabilities of the program and what sharing and downloading and distributing was going on that is not present here. The last thing, yesterday afternoon, the government sent a case to me called Taylor, which I'm afraid that I don't have the site for because I thought the government was going to rely on it. I can find it if you give me a moment. But the Taylor case that the government suggested it might rely on was a Fourth Circuit case, and the citation is 659 F3rd 339, a 2011 case. And that's a firearm case where dealing with the enhancement for having a stolen firearm. And the court said that it doesn't matter if the defendant knows that the firearm is stolen, but the firearm guideline has an express provision that says it's irrelevant. It applies regardless of whether the defendant knew. And so we think, and this may be why the government didn't mention it in its argument, we think that case actually helps us, that the commission knows how to write a provision that applies strict liability and says that an enhancement or a provision applies regardless of the defendant's knowledge, and it chose not to do so in 2G 2.2. So we think that that is an additional argument in our favor, and I thank the government for bringing it to our attention. And then lastly, I think we'll just rely on our argument about Layton is really about, we recognize that it's not the same guidelines provision, but what this court should do is read the guideline as a whole and treat like concepts alike and not apply a narrow restricted definition of distribution there, but then apply a definition so broad in this context, it would really defeat what it did in Layton and what the commission did in response to Layton in adopting it. So unless there are any further questions now, we would ask the court to vacate Mr. Miltier's sentence and remand for a resentencing hearing.
Thank you both for your arguments. We appreciate them. Well, I ask the clerk to adjourn court.
This honorable court stands adjourned. Sine die. God save the United States and this honorable court.
Judges, if it's all right with you, I can move you in